Welcome to another HalfQ session. This is the second video in the series You and Your Bank Account. Do you know why natural and legal persons are excluded from interfering with your banking relationships? Stick around and find out. If you're a holder or a potential holder of a bank account, this series is highly recommended to watch, and the videos are easy to follow no matter your background. There are timestamps in the description for ease of navigation, and references will be provided at the end of each video. The focus for this video is on the second out of 10 things you should know about your bank account. In the last video, we looked at the contractual nature of banking relationships, and we learned that there is a basic banking contract on your current or savings account. Also, we saw that banking contracts are usually written contracts which either put some duties on the bank or shed some off the bank depending on the conditions attached. Today we will consider the different types of parties to a banking contract and what it really means for you to be a party to these contracts. Please do not be too presumptuous. The topic is not as straightforward, but we promise to keep the legal jargons to a minimum. So let's get to it. Okay, banker-customer relationships require a specifically generated NUBAN. It is expected that a NUBAN must be used to identify a customer's account at every interaction with the bank. For bank operations, the convention is to link each customer's NUBAN to their means of identification, their mandate, and where applicable, their user credentials. The rationale is to profile the person to the account. This way, bank accounts are person-specific, since the license that banks have empower them to deal with persons. That said, the second thing to know about your bank account is that your banking contract excludes every other natural or legal person from interfering with your banking relationship. Well, natural persons are you and me, but legal persons are personalities created by incorporation. Just think of incorporation as many people bundled together and considered in law as one person with a separate identity. The scope of corporate law is heavy-handed with excruciating details. Maybe if you'd like another video on incorporation procedures, the definition of a person, and legal personality, just indicate that in the comments box below or via our email so we don't bombard you with tons of heavy legal stuff. In the eyes of the law, only natural or legal persons can be parties to banking contracts in their own name and rights. The operative word here is may, not can. The argument is flawed to assume any person with legal personality can enter into a banking contract. There could be limitations on the capacity of a person to enter into banking contracts. Let's bucket the types of persons as either statutory bodies, corporations, or individuals in order to examine these limitations and their capacity to interfere with the banking relationships of others. The first parties we would consider are statutory bodies. These are bodies incorporated into the society by legislation. It is easy to know if a statutory body can enter into a banking contract. Just check the enabling law. That shouldn't be hard. Anyone can. Any law in Nigeria becomes public knowledge once it is gazetted. Gazetting is how the government publishes a law after it is passed by the relevant lawmakers and the executive arm of government has given assent to the law. Never mind the nitty-gritties. If there is no law establishing a statutory body, or if the law establishing a statutory body ceases to exist, or if the lawmakers have expressly excluded the power for that body to enter into banking contracts, such a statutory body is incompetent and cannot maintain banking relationships. For example, the Anti-Money Laundering Act insists on the authorization of the Accountant General before an account is opened for a government body. Also, the Fiscal Responsibilities Act has qualified some lending contracts between banks and MDAs as unlawful. To this extent, such bodies cannot be parties to a banking contract. Next, the Treasury Single Account Initiative puts some limitations on bank accounts held by ministries, departments, and agencies of government. Accounts can only be held by banks for such bodies under the supervision or oversight of the Treasury Department. These accounts must be held only as zero balance accounts unless that bank is nominated by the Treasury to solely host the main Treasury account. Now, ZBAs are end-of-day transit accounts that must not carry a credit balance over to the next day. All monies in them have to be remitted or zeroized to the main account daily. Anything else is disallowed. The most remarkable thing about statutory bodies is that where the law permits, they are the only category of persons that have the capacity to interfere with the banking contracts of other persons, either by enforcing a law or by imposing a regulation. Moving on. The second bucket we will consider are corporations, namely companies, limited liability partnerships, and incorporated trustees. The law allows individuals to combine and form legal entities for business purposes, non-profit causes, or other endeavors bearing on a common or shared interest. However, only these three subsets have legal personalities. The capacity of corporations to maintain banking relationships is determined by the documents of incorporation and the management of the organization. For both of these, banks need to have sufficient notice. Not all employees of a corporation can initiate banking relationships on its behalf. For companies, it is only the directors and company secretary that can. For limited liability partnerships, it is the partners who can. And for incorporated trustees, it is only the members of the board of trustees that can. In the light of this, the Anti-Money Laundering Act allows banks to excuse that thick veil of incorporation and carefully look at the incorporation documents to determine which individuals to deal with and what competence such individuals have to undertake a banking relationship for the organization. Most times, the officers of a corporation would, among themselves, nominate the authorized signatories for probity and consistency as a safeguard against fraud and as part of the bank's due diligence when opening accounts for corporations. Banks must conduct independent verification with the Corporate Affairs Commission on the corporation's identity as contained in the Certificate of Incorporation. It is important to state that this category of legal persons cannot interfere with the accounts or banking relationships of others without an order of a court of competent jurisdiction. That said, the third bucket we will consider are individuals, in other words, natural persons. Whether male or female, the law regards the competence of individuals to enter into contracts based on mental capacity, that is, both consciousness and comprehension. Under normal circumstances, natural persons are presumed to have the dual ability to undertake activities and understand implications. But in reality, not all individuals can fully exercise this dual ability due to disadvantage caused by age, other handicap, or insanity. To start with, the law considers an individual's mental development by age as either an adult or a minor. As against common law, the maturity age line in Nigeria is 18 years. Persons at and over the age of majority have no disadvantage by age and are free to make contracts with banks. Only minors have this age disadvantage, and it is not the same for all minors. Arguably, teenagers have fair understanding of actions and consequences, but they still cannot fully appreciate the implication of certain contracts. The case is even worse both ways for toddlers. For these reasons, minors have punctuated legal personalities. Banking-wise, minors fall into the category of the socially and financially disadvantaged. Now, in the interest of financial inclusion, CBN's anti-money laundering regulation makes special allowance for the maintenance of bank accounts by young persons, students both within and outside Nigeria, and pupils through a school-related scheme. To reinforce identification requirements on these categories of minors, letters from persons in positions of responsibility like teachers, doctors, solicitors, and religious leaders will be required, and their accounts will be closely monitored by banks. Well, the other alternative for a minor is to have accounts held or operated for them by parents, guardians, or persons acting indefinitely in loco parentis, meaning persons with indefinite parental responsibilities towards that minor. Moving on. For natural persons, the law also considers comprehension handicap. A party to a contract should be able to demonstrate at his or her peril sufficient understanding of the contract. However, illiteracy and blindness can significantly hinder a person's comprehension of documents. If the contract is transcribed to another language to accommodate the illiterate, or if the contract is typed in braille form to accommodate the blind, the disadvantage may shift to the other party who may not understand documents written in the new language or in braille form. One of the parties will still be vulnerable to fraud or exploitation. Illiterates protection laws in Nigeria remedy these handicaps by introducing a neutral party or an interpreter. A magistrate or a justice of the peace will issue a judicial certificate called a jurat on the document to confirm that the contents have been read to the handicap and that such persons satisfactorily understand the document before thumbprinting or signing it. Ultimately, banking contracts that fail to fulfill this procedure will be unenforceable by banks, but not for the handicap. Okay, at the crux of it all, the law considers a disadvantage brought by insanity. The law is sympathetic to persons adjudged to be incapable of managing their affairs due to mental infirmity arising from old age or disease. As such, the law is willing to protect prior contractual obligations of such persons. There are prescribed procedures for appointment of other persons to administer and manage the estate of an incapable person. Banking regulations in Nigeria allow the maintenance of banking relationship in such situations by third parties or attorneys. banks are mandated to always cross-check transactions against the powers granted in these situations in order to curb fraud, money laundering, or terrorist financing activities. Where a banking contract is unknowingly made with an incapable person, the contract will not be void but voidable, and it is impractical for a bank after carrying out due diligence to make contracts directly with such persons, since such contracts are voidable and disadvantageous to them. Just like corporations, natural persons cannot interfere with the contracts or banking relationships of others without a court order. Having looked at these three buckets of legal personalities, a question then arises here. Is it only those with legal personalities that can maintain banking relationships? The answer is an emphatic yes. However, the freedom persons have to enter into banking contracts can be exercised either in singular or in plural, individually or jointly on one or multiple accounts. For financial inclusion and ease of access to financial services in Nigeria, banking relationships can be maintained by a group of persons without incorporation. These include registered or unregistered businesses that have no legal personality, relationships that are made for specific purpose arrangements, free associations between persons or other legal arrangements. What you need to understand is that these accounts could be operated by multiple persons and can be held either in multiple names or in names other than the names of the persons entering the contract with the bank. As these arrangements do not create legal personalities, the persons behind the arrangements will be held liable under any banking contract made for that arrangement. Moreover, the regulation in Nigeria is heavy-handed on tracing, tracking, and tying banking relationships to natural persons or individuals behind any arrangement. As a result, banks must properly identify the authorized signatories, persons exercising ownership, and persons exercising control over these arrangements. Okay, that aside, whoever the party to a banking contract is, banks must have documentary knowledge of the customer or a point of reference used to confirm whether a transaction emanated from the authorized signatory. This way, banks can prevent the interference of unauthorized persons using the records on their computers and servers. After all, anywhere access is needed on something, the intention is to exclude other things from it. Well, as people don't have names and particulars tattooed on their foreheads, the best way to identify an individual is by means of IDs, tax identification numbers, phone numbers, and address verification. There are only 4 acceptable means of identification in Nigeria as at August 2021, and they are the National ID card, INEX registration card, driver's license, and you have the international passport. In addition to these, parties are mandated under CBN's regulatory framework to submit a bank verification number before initiating banking relationships. So what's the implication of being a party to a basic banking contract? The implication is that you get assigned an account with which you can transact to the exclusion of all others. This exclusion of outsiders is called privity of contracts. In subsequent videos, we will look at the rights an account holder has and what role privity of contracts play in banking relationships. This brings us to a close for this video. And just to recap what was shared in this video, let's remember that banking contracts are specific and exclusive to persons with legal personalities. In addition, as was discussed in this video, not all entities or legal arrangements have legal personality. Then again, banks must consider the legal capacity of the customer with whom they enter into contracts. Furthermore, for arrangements that have no legal personality, the persons behind such arrangements must take responsibility and bear liabilities arising from contracts made with the bank. And most importantly, banks need documentary knowledge of their customers so as to pin persons to accounts. Just a quick tip, always pay jealous attention to your banking details and credentials. They are specifically for personal identification and authorization. Here are some key references for your further reading. Some of the links are in the description below along with the timestamps. We will consider the third thing you must know about your bank account in the next video. Please let us know in the comment box below or via our email if you need further clarification on any of the subjects in this video. See you in the next video.